Hot dog, I got 9 extra minutes. All right, you guys have been listening to lawyers for an hour, and appreciate how you guys are all holding up so far. I'm going to ask you to hold on just a little bit longer. I'm pretty sure the next panel is non-lawyers. Is that right? So you have that to look forward to. My name is David Sigale. I am a practitioner in Glen Ellen, Illinois, just outside of Chicago, and I represent the Second Amendment Foundation on a number of matters, and I am also counsel for the Illinois State Rifle Association. Shout out to the good guys over there. And Illinois Carry is also out that way, and I represent them. And quite frankly, without those groups, there's no way that I could be doing what I'm doing. So thank you all these groups for their help, and especially for staff for giving this platform to talk to you today. There's a number of things going on in Illinois and really across the United States that I wanted to talk to you about today. Try to give you the abbreviated versions, though. There are 3 cases, Miller versus Walker, Johnson versus Lyon, Attaway versus Corsi. Those cases are in Illinois and Michigan and Missouri, respectively. They all have they all concern the issue of Second Amendment rights for foster parents. The states all have rules that if you are a foster parent in that state, you must abide by certain regulations, which generally include disarming yourself. They all put in force, what the governments like to call safe storage requirements, where you have to have your firearm and your ammunition in separate locations and separate safes, and that does you pretty much no good if someone happens to break in at 2 a.m. Also, if you are licensed to carry, you're not allowed to carry on your person in the home, and if you happen to have a carry permit outside the home, well, too bad, you're not allowed to do that either. The Miller case in Illinois also challenges similar restrictions for home daycare providers. Now, let's be very clear about all of these cases. These cases are not about acting stupid and leaving guns in the toy box or anything like that. It is about carrying them, storing them responsibly, but also storing them, being able to carry or store them in such a fashion that if you actually need them, you'd be able to use them. So, for example, in those cases, the plaintiffs are not challenging, say, when you're not using the firearm, lock it up in a safe, but they want to be able to lock it up loaded, so that at 2 a.m., if they need to open the safe, they have it ready for them. The Illinois case is in the discovery period, so is the Michigan case. The Missouri case is kind of in a forced settlement type of stage. The court wanted to see if it could be worked out, and so we're trying to, and we'll see what happens with that. Missouri, of course, has a constitutional carry state, and they recently added to their constitution a strict scrutiny standard that for Second Amendment rights. And we're hoping that action will spur the government to come to see reason on this case. So that's what's going on there. A number of people have talked about housing authority cases. We filed, and by we, I guess, SAF, ISRA, what we filed as Doe versus East St. Louis Housing Authority. This was a case where we had to file it under a pseudonym because the housing authority resident had a violent ex-paramour recently out of prison who threatened to kill her if he ever found her. In the meantime, she's living in a housing authority where if she has a firearm in her home for self-defense, she can get kicked out. At the same time, she had been attacked and sexually assaulted in her own house, and the only thing that saved her was her kid getting the gun out of the safe, which scared the guy off. The the housing authority saw reason on that one. They were able to agree to an injunction, and that case has been won. And this is real nice. It's nice to have, a pat on the back and attaboy, but when you do this job, when you have a client crying in happiness on the other side of the phone, when you tell her that the authority, the government, whatever's got the boot on her neck is no longer going to be able to do so. That's why I do this. There's a couple cases. You also referenced to it earlier. One is called Cole versus Norridge, Illinois. One is called Second Amendment versus City of Chicago. Both of them are challenges to gun store bans. Both of them were pending for a very long time, and it took all that time to basically get the village, get the city to change their restrictions, change their regulations. They kept doing it incrementally, as government often does. They would say, okay, well, we're not going to ban it anymore, but you can only have it here. Okay, well, you can't just have it here, you can have it in other places, but you got to do this, and so on and so forth. So the Norridge case was recently resolved after the village finally loosened its restrictions enough. In the City of Chicago case, they had to repeal their gun store ban, and now that case is still in its pending stages on damages. The Wilson case, Wilson versus Cook County, is the assault weapon case. There is a cert petition. We lost at the Seventh Circuit. There's a cert petition due towards the end of November. We were trying to weave the case around the 2015 Friedman case in the Seventh Circuit, which basically upheld a ban on assault weapons. We said this one is different. Cook County as a whole is different from Highland Park, Illinois. You have to allow us to take that into the consideration. The Seventh Circuit said, no, we really don't see a difference. And they dismissed our complaint and upheld the dismissal of our complaint. And now we are, like I said, heading for a cert petition on that. Case of Culp versus Madigan, now Culp versus Raoul. The state has a virtual ban on almost every non-Illinois resident from actually applying for a concealed carry license. The courts, unfortunately, have upheld that regulation, that restriction. They've said, well, we don't know we don't know if we can trust the people, and we have no way of knowing. And we've said, well, you don't know if you can trust Illinois residents either, and yet you give concealed carry license people that go through the training are qualified. You should do the same for other people in other states as well. The cert petition will be coming in a couple weeks for that one. Also in the vein of assault weapons is the Easterday versus Village of Deerfield case. This is a case where village, after the state changed its gun laws in 2013, changed its licensing laws and whatnot, and said, we're taking over. We are preempting this field of assault weapons. If you want to get in and do something different, you have right now to do it. Deerfield said, okay, we'll have a bunch of restrictions, storage requirements, and whatnot. 5 years later, they say, that's not good enough, we're going to ban them. We sued them saying, well, state preemption controls that. The court has agreed with us, and they entered a permanent injunction. But the court recently made a ruling that's going to allow Deerfield to appeal that to the Illinois Appellate Court, so we'll be seeing how that goes. I'm actually surprised I haven't gotten that notice of appeal yet, but I'm sure it's coming. Lastly, is a couple cases regarding Illinois is one of 3 states that requires you to have a firearm license just to possess a firearm. Massachusetts, I think, is the second, and New York requires one for handguns. If you just want to possess one in your home. A woman in downstate Illinois, her ex-husband, or her some status of husband, called the police on her, said she's firing a gun in the house. Cops showed up, and no, she wasn't. But the cops did find the 22, the rifle that she had, by the bolt action by her bed for protection, and charged her with not having a firearm license, a firearm owner ID card, a FOID card. The judge struck the license requirement down as unconstitutional for requiring someone just who's law-abiding to just have a long gun by their bed or in their home for self-defense. Judge said it's unconstitutional to require you to have a license. The state appealed that to the Illinois Supreme Court. Those arguments were 10 days ago, and we'll see how that turns out. I would hope that the argument that this is something that in the day of the framers people were required to do, and in fact in one instance the state even paid for a firearm if you didn't have one, to have one for protection. So hopefully the court will see. And I made the point, to be clear, it's not about handguns, it's not about buying guns, selling guns, anything like that. But if you want, like in colonial days, a long gun for protection, you should be able to have it. In closing, in addition to this, the state likes to take gun rights away and they don't like to give them back. People appeal and they say, I should have my rights back. They don't get them. And sometimes they force us to go to court. Sometimes the denials are ridiculous. We'll be filing suits very soon to overturn what is really just a broken system of restoring FOID rights, returning concealed carry rights. We're doing this on an individual basis. We're going to be having a vehicle very soon to try and make this a bigger issue to help all the people of Illinois. And I guess I'll update you all that next year. So thank you very much.